Hello and welcome everyone to Balliol College, Oxford for the 2021 Bingham Lecture in Constitutional Studies. My name is Dr. Nick Dickinson and I'm the Bingham Fellow here at Balliol. The lecture and the fellowship are part of the Constitutional Studies programme here, which is generously supported by a benefactor to the college and which also includes a term seminar. And the aim of the programme is to increase awareness of constitutional issues in British public life. The yearly lecture in that vein has been previously given by a range of eminent scholars and practitioners in British politics, including Jessie Norman MP, Professor Anand Menon, the Professor Lord Norton of Louth, whose 2019 lecture was subsequently published in the journal Parliamentary Affairs, and last year, of course, as many of you will have seen, by Professor Timothy Endicott, formerly of Balliol and now the Venerian Professor of English Law here at Oxford. And in that tradition, it's my pleasure to introduce the Bingham Lecturer for 2021, Dr. Hannah White. Hannah is the Deputy Director of the Institute for Government, where she oversees its programme of research on government, Parliament and the civil service, and leads on its work on Parliament. Before joining the Institute in 2015, Hannah spent a decade working in Westminster and Whitehall. Before running the Committee on Standards and Public Life within the Cabinet Office, she was a clerk in the House of Commons, managing select and legislative committees and advising on parliamentary procedure. Many of you, however, will know Hannah, of course, as a regular commentator for radio and television and in her writing for a range of media outlets, including The Guardian, The Times and The Telegraph. She's also Deputy Chair of Trustees of the public participation charity Involve and received an OBE in the 2020 birthday honours this year for services to the Constitution. And again, as you'll have seen, the title of Hannah's lecture this year is Against the Clock, Brexit, Covid-19 and the Constitution. Time pressure is a necessary constraint on aspects of the Constitution, but it can also pose a threat to good government, parliamentary accountability and scrutiny. And so in this lecture, Hannah will consider the impact of the Constitution on of time constraints created both by the Article 50 process and more recently during the COVID-19 pandemic. And she'll also examine the ways in which time pressure shaped the May and Johnson's government's strategies for giving effect to the 2016 referendum and how they controlled time in pursuit of their policy objectives. And in concluding, she'll reflect on the lasting legacy of time pressure exerted on the Constitution during these exceptional periods, which we have all lived through. So before I hand over to Hannah then for the lecture, just a few quick details about how the event will run. Which will be familiar to those of you who attended our previous Bingham seminar last term. So the lecture will last for around an hour, but this will leave time for questions at the end, with the event finishing around 6:30. The questions can be posed using the Q&A box, which should appear at the bottom of your screen, where you can also vote for other questions that you would particularly like to be answered so that they rise to the top and we see them. And then I will then ask those questions on your behalf to Hannah at the end of the lecture. So without further delay then, I will hand over to Hannah for the 2021 Bingham Lecture in Constitutional Studies.
Thank you very much, Nick. It's a real honour to have been invited to give the Bingham Lecture this evening. I'm sorry that I never had the pleasure of meeting Lord Bingham, but I'm lucky enough to have worked with many people whose thinking has been shaped by his judgments and by his seminal work on the rule of law. It's a great shame, I think, that over the past constitutionally eventful decade, we've been unable to benefit from Tom Bingham's erudition and clarity of thought. In his absence, we have to make our own attempts to think through the significance of what we're witnessing. I hope that my lecture this evening provides some insight into the theme I've chosen to explore, which is the significance of time pressure for the operation of the Constitution. Time is a crucial facet in the operation of the Constitution. It governs practices within the institutions of the state and the relationships between them. Parliamentary procedures and practices are full of references to time, deadlines for tabling amendments, guillotines on the length of debate, allocations of days for different types of business. At a day-to-day level, rules to deter filibustering and limitations on the length of debates ensure that the Commons and the Lords can get through their business. The working of the executive is currently framed at the outer limit by the 5-year interval between general elections specified in the Fixed Term Parliaments Act. The government has made clear that the Act's time will shortly be up, but in repealing the FTPA, it intends to restore a 5-year limit on the time between elections. Time constraint also helps shape the relationship between the branches of the Constitution. In between elections, the legislative activity of the executive is normally disciplined by the convention of an annual cycle of parliamentary sessions. Although a session is normally a year, in the last decade, we have seen both the longest session on modern record, which began following the 2017 election and clocked up 349 sitting days, and the one which followed it, which was one of the shortest sessions ever, lasting just 15 days. The time limitation of a parliamentary session helps the government to shape its lawmaking efforts. And although some bills may be carried over between sessions, for example, 6 have been carried over from the last session into the one that's just started, the sessional pattern provides an incentive to drive compromise between political parties as each parliamentary year draws to a close. Time limits also discipline the executive over briefer periods. Who knows how long the government would take to answer parliamentary questions without the existence of rules that set a day for answer, or how long it would take to respond to select committee reports without the convention that it should do so within 60 days. In 2017, the Institute for Government found that only 30% of select committee reports received a response within the agreed timeframe, the average being 75 days. And just as conventions and rules about time can be constructive and necessary, an absence of time constraint can be problematic. The most obvious example of this is public inquiries, with the famously long Bloody Sunday inquiry, which ran for 12 years, even outlasted by the lower profile inquiry into hyponatremia-related deaths, which took 13 years and 3 months. The lack of constraint on the length of public inquiries, unlike the informal limit of 1 year on inquests, can mean that many of those affected end up feeling that justice delayed has been justice denied. Long public inquiries can also impede the ability of government to learn lessons from past mistakes. One reason why the government's decision to delay the start of a public inquiry into COVID-19 until the spring of 2022 is problematic. So, time constraints or their absence are crucial in determining how the Constitution operates. So far, I've been discussing the choices which the different branches of the Constitution have made to govern their own and each other's time. What I want to talk about today is something slightly different, and that is the impact on the Constitution when it is placed under external time constraints, deadlines and time pressures, which are to a significant degree, although perhaps not entirely, beyond the control of constitutional actors. In the past 5 years, we have seen 2 major examples of the Constitution operating under externally imposed time constraints: the 2-year deadline of the Article 50 process for leaving the EU, and the urgent imperative for government of responding to the spread of COVID-19. Today, I want to explore the impact of those time constraints on the Constitution and on the conduct of government over the past 5 years, and ask how we should be thinking about protecting the Constitution from the risks created. Although I'm going to focus on the time pressure created by Brexit and COVID-19, it's important to acknowledge that they both happened during a period in which it's generally accepted that the pace of public life has anyway been quickening. Of course, a week has always been a long time in politics, as Harold Wilson so famously said, but in recent decades, other factors have been accelerating the processes of governing the country. Often cited is the emergence in the 1990s of the 24-hour news cycle, driven by cable television, putting a premium on the rapid reporting of novelty in order to secure audience share and advertiser revenue. This, in turn, prompted a shift in political news management, the emergence of the political grid, designed to deliver a constant feed of pre-briefing, contemporaneous content, and post-match analysis. The arrival of social media cemented the requirement for rapid reaction. No more waiting for a response from government in tomorrow's broadsheet. Meanwhile, platforms such as Facebook and Twitter have decreased the distance and removed the mediators between constitutional actors and the public, with Donald Trump's Twitter account perhaps representing the apotheosis of these trends. Meanwhile, WhatsApp has become a key medium for political exchange, allowing ministers the means to progress official business quickly outside the slower processes of meetings and memorandums, but creating concomitant difficulties for the formal recording of government business. The acceleration of public life has shaped government by creating an atmosphere in which speed and decisiveness can be valued over reflection and planning. One of the objections of the Johnson government to judicial review has been that it creates needless delays to the business of government. The alternative view, expressed in a recent IFG report, is that while judicial review can be time-consuming and onerous, like other forms of scrutiny and challenge, it can also help ministers to govern more effectively. The consequences of the acceleration of public life flow through to Parliament, of course, where the wish of politicians to demonstrate to the public that they are acting expeditiously has shaped the legislative process in recent decades. We have seen this in a growing political penchant for declaratory bills, legislation which is arguably unnecessary, except to signify that something has been done. We have seen it in ministers' increasing comfort with the use of emergency procedures to pass bills quickly, for very good or less good reasons. And we have seen it in a trend towards more and more skeleton bills, which have minimal policy content, but create sweeping powers for ministers to fill in the detail afterwards. More of these later. So if this was anyway the context in which the Constitution was operating, what difference did Brexit and the pandemic make? I'll start with Article 50 of the Treaty on the European Union, which, as you all know, sets out the process for a member state to withdraw from the EU. The time pressure Article 50 created was a significant factor shaping the outcome of Brexit, as Professor Kenneth Armstrong has explored in much greater detail than is possible for me today, including in his book, Brexit Time. Article 50 was not a founding element of the European Union. It was an exit right demanded by the Eastern countries that acceded in 2004 as a protection against future unwelcome policy changes. As Lord Kerr, one of those responsible for drafting the provision, has made clear, Article 50 was intended to prevent legal chaos if a member state chose to leave the EU. But rather than simply set out a divorce process, its authors also included a 2-year time limit that could only be extended with the unanimous agreement of all member states. The purpose of Article 50 was to concentrate minds and to embed the power disparity that could anyway exist between any departing state and the remaining EU bloc. To quote one EU diplomat who spoke to The Guardian in 2016, "The moment you push the button, you're in a stupid negotiating position." This was because the consequences of a no-deal exit would always be worse for the departing state than for the EU. So how did the time constraint imposed by Article 50 shape the government's strategy for giving effect to the 2016 referendum result? During the referendum campaign, David Cameron argued that he would be compelled to trigger Article 50 immediately following a Leave win. After the referendum had been held, this looked less advisable, and Boris Johnson, among others, argued it would be far more sensible to hold informal talks with the EU to thrash out the outline of a settlement before triggering the formal process. But 3 key pressures led Theresa May to embrace the constrained timetable. The first was the political pressure which began to build from some leavers who suspected Parliament might attempt to delay or reverse the referendum decision and worried that the longer that Brexit took, the greater the risk that public opinion could turn against them. Second, and of course linked, Theresa May, after having campaigned for Remain, personally needed to prove her new loyalty to Brexit and wanted to win back UKIP voters to the Conservative Party. Third, and most significantly, the European Union took a position of no negotiation without notification, refusing to engage in negotiations prior to Article 50 being triggered. Together, these pressures led to May's commitment to trigger Article 50 before the end of March 2017. This commitment itself triggered the first major constitutional test of the Brexit process, the Supreme Court challenge to the government's proposed use of its prerogative to notify the EU of the UK's intention to depart. The judgment, which went against the government, was the first example of the court's general approach to Article 50 time pressure, seeing it as a reason for protecting and defending scrutiny of the executive. Gina Miller's successful challenge theoretically strengthened Parliament's role in the notification process, but in practice, even MPs who had campaigned for Remain felt compelled to demonstrate that they were not standing in the way of Brexit, and so supported the bill that the government brought forward to secure parliamentary approval for notification. However, as many MPs acknowledged privately at the time, May's decision to set the clock ticking weakened the UK's negotiating position because it started the Article 50 process before the UK Cabinet had reached agreement on the UK's negotiating stance, and while key EU politicians were distracted by the French and German elections. This weakened position was illustrated from the start of the negotiations. The UK government expressly said that its first negotiating demand would be on the timetable for the talks, with the Brexit Secretary David Davis boasting in May 2017 that this would be the row of the summer. But just a month later, the UK had capitulated to the EU's demands on the content and timing of the talks. This was a portent of the way talks were to proceed. The time pressure of Article 50 had a dramatic impact on the way the May and Johnson governments handled Brexit domestically, with some serious constitutional consequences. I'll pick out what I think are 5 of the most significant impacts here. First, the existence of the Article 50 deadline persuaded Theresa May to adopt a strategy of sidelining Parliament in her negotiations with the EU, working on the assumption, as it turned out a misguided one, that in the end, time pressure would compel MPs and peers to support whatever deal she reached in preference to the potential chaos of a no-deal exit. Assuming that her deal, as the only one on the table, would eventually be agreed, May made no attempt to allow for parliamentary debate around her red lines or negotiating objectives, simply asserting that ministers could not give a running commentary on the talks and frustrating parliamentarians' attempts at scrutiny, with her government eventually becoming the first ever to be found in contempt of Parliament for refusing to share legal advice on her proposed deal. The same psychological phenomenon, incidentally, contributed to Parliament's inability to reach consensus on the Brexit deal. As the Article 50 deadline approached, each of the different parliamentary factions, those supporting a hard Brexit, a soft Brexit, or opposing Brexit altogether, perceived that pressure was growing on the other factions. The existence of the deadline created parliamentary gridlock. There was no incentive for anyone to move position until it arrived, because someone else might move first. The second consequence of the Article 50 deadline was that the government did not have time to pass primary legislation to give legal effect to the UK's departure. Instead, ministers took extraordinarily broad powers to handle the translation of EU statute into domestic law using secondary legislation. This included extensive Henry VIII powers, which allowed ministers to amend and even repeal existing acts using secondary legislation. During the Brexit period, what Tom Bingham called the legislative hyperactivity, which appears to have become a permanent feature of our governance, was put on steroids. This was troubling from a rule of law perspective because of the extent of the legal changes that were made subject only to the weak parliamentary scrutiny available for secondary legislation, deficiencies that have been extensively documented by the Hansard Society. MPs and peers agreed to grant ministers these powers in return for sifting mechanisms, which gave them a limited degree of influence over the method of scrutiny used for some secondary instruments, although the evidence is that the government was effectively able to circumvent this control. In addition to the powers created by core Brexit legislation, other bills passed subsequently to create a legal basis for government to take back control of policy areas from the EU over immigration and agriculture and so on, have been similarly short on content. The time pressure created by the Article 50 deadline has been used to justify the necessity of providing ministers with powers to fill in policy detail without the parliamentary scrutiny we might normally have expected. Thirdly, and again on the theme of rule of law concerns, the compressed Article 50 timetable radically shortened the time available for parliamentary scrutiny of key constitutional statutes. Parliament was able to conduct valuable and constructive scrutiny of the EU Withdrawal Act 2018 over the course of a year, but the EU Withdrawal Agreement Act, a major constitutional act which effectively rewrote the UK's post-Brexit constitutional framework, was considered over the course of just a single month, the final version having been published only the day before it received its second reading in the Commons. More concerningly still, the European Union Future Relationship Act 2020, which allowed for ratification of the EU-UK Trade and Cooperation Agreement, was introduced to and passed by the UK Parliament in a single day on the 30th of December 2020. Just for comparison, the Maastricht Treaty was considered over a period of more than 400 days, and MPs and peers spent 25 days scrutinising the Lisbon Treaty over a period of nearly 200 days. The 31st of December deadline was used to justify the lightning fast passage of the bill in the few days remaining after the treaty had been agreed. But Professor Jeff King has argued that the rapid passage of the Future Relationship Act was a political choice rather than a legal or logistical necessity, noting the different approach taken by the EU, which provided for provisional application of the treaty pending ratification by the EU Parliament. My fourth point is that the Brexit process has put pressure on our territorial constitution, and the time constraint of the Article 50 process has undoubtedly contributed to the strain. It is not clear to what extent time pressure played a role in the way the UK government handled the differences of view expressed by Scotland, Northern Ireland and Wales on Brexit, and whether if time had not been an issue, any greater degree of consensus might have been sought or found. But it is definitely true that the disputes that have arisen between the four legislatures over key pieces of Brexit legislation have undermined the Sewell Convention, which is the convention that the UK government will not normally legislate without the consent of the devolved legislatures. The decision of the UK government to pass several Brexit bills without consent has led to a breakdown in consensus about how the Sewell Convention should operate. Devolved governments have argued that the UK government flouted its obligation to consult in good time before introducing a bill and to seek compromise to resolve any disputes. Finally, the impending Article 50 deadline contributed to Boris Johnson's highly controversial decision to prorogue Parliament for 5 weeks in September 2019. By the time Boris Johnson came into office on a promise to deliver Brexit, there was considerable frustration among the Leave voting public about the time parliamentarians were taking to deliver on the referendum result. This added to the pressure on the government to bring the Article 50 process to an end. Although Johnson argued the prorogation was simply a means to begin a new parliamentary session, it was clearly also intended to prevent parliamentarians thwarting his plan to take the UK out of the EU with or without a deal by the 31st of October. Had there not been an external deadline for departure, just a domestic political commitment, there would have been no benefit to the extended suspension of Parliament. The shortness of time under Article 50 and the length of time for which Parliament was to stand prorogued were also key aspects of the Supreme Court's decision to nullify the prorogation, with the court again seeing time pressure as a reason to defend Parliament's ability to scrutinise the executive. The 11 judges argued that such a long prorogation in the run-up to the 31st of October deadline would, to quote from the judgment, have the effect of frustrating or preventing, without reasonable justification, the ability of Parliament to carry out its constitutional functions as a legislature and as the body responsible for the supervision of the executive. Lady Hale stated that the longer that Parliament stands prorogued, the greater the risk that responsible government may be replaced by unaccountable government, the antithesis of the democratic model. Although the prorogation itself was nullified and even removed from the parliamentary records, its wider consequences could not be so easily expunged. It created extreme levels of tension between the government and Parliament, made visible in hostile scenes in the Commons chamber. Backbenchers and opposition parties accused the government of trying to close down democracy, while ministers accused Parliament of being dead and illegitimate and with no right to sit, because they felt it was thwarting the will of the people as expressed in the referendum. The sight of this conflict cannot have been anything but corrosive to the public's view of democracy. The Supreme Court judgment against the government increased tensions between the government and the courts. This was acute in the autumn of 2019, but we are still seeing its effects, including in the government's legislative plans for the current session. Following a consultation by the Lord Chancellor on various proposals to make it more difficult, and in some circumstances potentially impossible, for the courts to rule, as the Supreme Court did in respect of the prorogation, that decisions of the executive are a nullity and so never happened, the government is proposing to legislate to restore the balance between government, Parliament and the courts. And the prorogation had further troubling consequences for the rule of law. The pressure of the impending prorogation led Conservative rebels and opposition parties to take control of the Commons agenda to pass a private member's bill, the so-called Benn Act, designed to prevent a no-deal exit. This controversial move resulted in rhetoric from government sources about Boris Johnson's willingness to ignore this act in order to fulfill his commitment to take the UK out of the EU by the 31st of October. Arguably, this first psychological foray into the possibility of the government not obeying the law eased the path to ministers' stated willingness to break international law with the UK Internal Markets Bill, albeit in a limited and specific way, a move which would clearly have contravened Tom Bingham's 8th principle of the rule of law. These are 5 of the ways in which the time constraint created by the Article 50 process affected the Constitution. Of course, time constraint was not the only factor. Minority government and the political divisiveness of Brexit were also highly significant. But I think it is important to reflect on the way that time constraint may have contributed to the setting of precedents and shaping of relationships between the branches of the Constitution in ways which would not have happened in slower time. I want to come now to my second case study of the Constitution operating at speed, the COVID-19 pandemic. In contrast to Article 50, which was a legal construct created by one set of political actors in the EU, which subsequently shaped the actions of others in the UK and Europe, the COVID-19 pandemic is a natural phenomenon which has compelled a simultaneous response from governments across the world. Some governments have chosen to ignore or downplay the implications of the pandemic, but we are starting to see them pay the price, either in terms of mounting tolls of illness and death, as in India, or in terms of electoral outcomes, as for Donald Trump in the United States. The UK government did not see a response to the pandemic as discretionary. The question was how best to respond, not whether. In answering this question, it soon became clear that speed was of the essence for several compelling reasons. The virus was spreading exponentially through the population, creating a growing burden of disease and death. There was the potential for the NHS to become overwhelmed, squeezing out provision of other essential health services. There were no effective treatments or preventative measures, at least until late 2020. And the UK was competing with other countries for finite resources, including PPE, ventilators, and oxygen. The challenge for government was how to act rapidly whilst also adhering as far as possible to constitutional norms and processes. Treading this very difficult line, the government made a series of decisions which deliberately departed from normal processes and arguably in some cases created risks to the Constitution. Again, I'll offer 5 examples. First, primary legislation in the form of the Coronavirus Act was passed to give the government additional powers to deal with the pandemic. While MPs and peers made some important amendments to the bill, the time for scrutiny was very limited. It went from publication to royal assent in under a week. and opportunities for dissent may have been restricted by difficulties with social distancing in the division lobbies, which prompted an agreement between the party whips to avoid votes in person. Second, having taken these new emergency powers, the government then chose instead to make extensive use of powers contained in an existing public health law, the Public Health Control of Disease Act 1984, to place unprecedented constraints on the UK population. Because ministers needed to move rapidly to lock down the country, the majority of these regulations were made using the so-called urgency procedure. This meant that most were not subject to parliamentary scrutiny until some time after they had come into force, or in some cases, only after they had been superseded by other regulations. The barrister Adam Wagner has argued that the government's use of secondary legislation during the pandemic has led to poor quality law that has been difficult to enforce. He's identified problems created by errors in drafting, inconsistencies between guidance and regulation, which have made the restrictions difficult for the public to understand and for the police to enforce, and the accumulation of regulations, with each being used to amend the last, making them increasingly difficult to understand, and certainly contravening Tom Bingham's prescription that the content of the law should be accessible to the public. The third way in which the government's initial response to the pandemic created risks to the Constitution was in departing from its own normal internal practices in order to act at speed. The exceptional nature of government activity during this period, and in particular of government spending, is demonstrated by the spike we have seen in ministerial directions. These are formal instructions from ministers authorising a spending proposal despite an objection from their permanent secretary on grounds of value for money, feasibility, propriety, or regularity. Since the spring of 2020, 14 ministerial directions relating to the pandemic have been published. To give you an idea of how unusual it is to see 14 directions in a year, in the 3 decades since 1990, we know of a total of only 92 directions having been made. Fourth, the government chose to reduce or suspend rules around public procurement to allow PPE and medical equipment such as ventilators to be obtained at speed, including permitting public bodies to make direct awards to suppliers without competition. This enabled the government to procure unprecedented volumes of essential supplies at great speed to protect key workers. But it also led to concerns about value for money and propriety. Of £17 billion of new contracts awarded to suppliers between March and July 2020, £10.5 billion were awarded directly without any competition. The National Audit Office has found that PPE supplies put forward by government officials, parliamentarians, and senior NHS staff were 10 times more likely to be successful in obtaining contracts than other suppliers. Fifth, in order to establish new bodies needed to respond to the pandemic as fast as possible, the government decided not to follow normal public appointments rules when appointing key figures to lead aspects of the pandemic response. 2 of the most high-profile appointments, which are now being challenged in court, were the selection of Kate Bingham to chair the Vaccine Task Force and Baroness Harding, first to lead NHS Test and Trace, and subsequently to be the interim executive chair of the new National Institute for Health Protection. While it is obvious that there wasn't time for a prolonged selection process for these key pandemic response roles, the Commissioner for Public Appointments, Peter Riddle, has expressed concern that making such appointments without due process may discourage talented and experienced people of all backgrounds from applying to run public bodies. Acting at high speed was clearly justified in the early months of the pandemic. Indeed, some have since criticised the government for not acting fast enough. For the courts, the time pressure created by COVID-19 has generally been seen as a reason to afford the executive greater latitude in its actions, unlike the court's response to the artificial time pressures of Brexit, which was to protect the scrutiny role of Parliament. In the Dolan case, for example, which was a challenge to the lockdown regulations, the High Court said, "The courts recognise the legitimacy of according a degree of discretion to a minister under the urgent pressure of events to take decisions which call for the evaluation of scientific evidence and advice as to the public health risks. However, as the pandemic has continued, concerns have been raised about the government's continued use of emergency powers and ongoing disapplication of its normal rules. By the autumn of 2020, for example, concern was growing in Parliament about the limitations on parliamentary scrutiny imposed by the government's continued use of the urgency procedure, what Professor Tom Hickman has called the government's abracadabra lawmaking. On the 30th of September, Sir Lindsay Hoyle, the House of Commons Speaker, said in a statement that the way in which the government has exercised their powers to make secondary legislation had been totally unsatisfactory and shown a total disregard for the House. A number of court cases have also challenged the government's use of secondary legislation, including judicial review challenges to regulations on lockdown, self-isolation, and travel restrictions. While the government has been at pains to express its reluctance to impose ongoing restrictions on the liberties of the population, its practices have, arguably, reflected a habit and even a preference for prioritising ease of executive action over restoring the protections of constitutional norms. I have outlined how the time pressure created by Article 50 in COVID-19 affected the operation of the Constitution over the past 5 years. But what, if anything, have been the lasting effects of these two episodes? After the time pressure of any emergency lifts, it might be that everything returns to normal in a constitutional sense. The rules rebound, relationships return to equilibrium, and institutions revert to the status quo. Or there may be lasting effects, ways in which the operation of the Constitution has been permanently changed by the effects of operating under time pressure. Some effects may be positive. Looking at my two case studies, we can see examples of innovations forced by time pressure that have shown their merit and may be retained. Examples include new practices established to deal with the volume of secondary legislation that needed to be passed to give effect to Brexit. Government seems likely to retain the new subcommittee of the Cabinet Office Parliamentary Business and Legislation Committee, which now oversees the process of government departments bringing forward secondary legislation, improving prioritisation and sequencing. And the House of Commons has added to the remit of the European Scrutiny Committee a sifting process for negative instruments laid under the EU Future Relationship Act. This was a process first invented to give Parliament a greater say over the procedure used for scrutinising regulations dealing with deficiencies in retained EU law. But other longer-term effects of the Constitution operating under time pressure may be less positive. These include decisions taken, judgments reached, and precedents set in exceptional circumstances, which will now have lasting effect. Laws passed during the last 5 years, including those which, as discussed, provide sweeping powers to ministers, will sit on the statute book unless they are subsequently repealed or have an expiration date built in. Case law and parliamentary precedents may continue to shape subsequent judgments. Many of these may be helpful, others less so. Previous decisions can, of course, be deemed to be bad precedents and disregarded in future. So Lindsay Hoyle has made clear, for example, that he would not have made some of the same controversial rulings as his predecessor as Speaker, John Bercow. But the uncodified nature of our Constitution makes precedent an important factor shaping its operation. As well as formal precedents, rule changes, and new laws, it seems inevitable that the last 5 years have established or reinforced habits among the people who operate our Constitution. Because the Constitution is not just about rules and institutions. It is about the people who operationalise those rules, make up the institutions, and embody the relationships between them. Throughout Brexit and COVID-19, time pressure has put different demands on rules, on individuals, and on institutions, which have shaped the way that they have operated. And these may have lasting effects. Two examples can illustrate this point. From the point of view of government, a whole cohort of ministers have become even more used to passing skeleton primary legislation and filling in the detail later with secondary legislation. This was a trend which had begun before 2016, but it is a way of working that has now become firmly embedded, encouraged by the dual attractions for ministers of not having to wait for parliamentary draftsmen to produce content-rich bills and not having to spend as much time in Public Bill Committee being tested on the detail of their policies. From the point of view of Parliament, the cohorts of new MPs who arrived in the Commons in 2017 and 2019, 187 MPs in total, have had their professional experience shaped by a period of parliamentary exception. Their expectations in terms of the time available for scrutiny and the openness of government have been fashioned during a period in which the government has used time pressure as justification to reduce scrutiny, has rushed through significant constitutional legislation, and has delivered extraordinarily momentous policies using secondary legislation that MPs have barely had a chance to consider. If the government tends to retain some of the habits that it has developed over the past 5 years, habits that have shifted power away from the legislature and towards the executive, will Parliament have the institutional memory to recognise what has happened? A further lasting effect from the last 5 years may be the way in which events have heightened tensions in relationships between the branches of the Constitution. The experience of Brexit has shaped a view in the Conservative Party that an imbalance has developed between government, Parliament and the courts. This was articulated in the 2019 Conservative Manifesto, which promised, and I quote, "a Constitution, Democracy and Rights Commission that will come up with proposals to restore trust in our institutions and in how democracy operates." Although the Commission itself has not yet materialised, a number of more limited reviews have taken place, including into judicial review, and last week's Queen's speech included references to the government's continuing determination to restore the balance of power between the executive legislature and the courts, and its intention to legislate to do so. It is obviously the prerogative of the elected government to legislate as it sees fit, if it can command the necessary majorities in Parliament. But there is a question, I think, about the desirability of a government making significant changes to the Constitution in response to its experience of governing during a very specific period. This is a point which should not be lost on the entire political class who are keen to get rid of the Fixed Term Parliaments Act, a law which was created in a hurry in 2010 to deal with the specific circumstances of the coalition government and has proved since to have significant unforeseen consequences. I turn now to some thoughts about how the Constitution might be protected against the negative consequences of operating under time constraint. I've argued that external time constraint may lead to precedents being set or changes being made inadvertently or in response to exceptional circumstances, which may then be repented at leisure. I realise it may sound as if I'm just arguing for everything to be done more slowly. In some instances, that would be desirable, but the examples I have discussed today demonstrate that it is neither politically realistic nor practically possible to remove external time pressures from the Constitution. What is important is to find ways of ensuring that constitutional processes are respected, even in the context of time pressure, not set aside because of it. I would suggest there are at least 3 routes to achieving this. All are already features of our Constitution, but some are perhaps not operating as effectively as they might. The first are mechanisms of accountability, ensuring that decision makers are aware that actions taken at speed will be revisited when the dust has settled, or ideally sooner. In theory, there are numerous accountability mechanisms built into the UK Constitution, but in practice, there are questions about how well they can operate under time constraint. The Article 50 process demonstrated the ability of the courts to act at pace to review and, where necessary, reverse government decisions. But parliamentary committees, I would argue, struggled to hold government to account in a meaningful way during the negotiation process. And, as Professor Meg Russell and Daniel Gover have argued, the government's control of time in the House of Commons, which is unusually strong in comparison to that of other governments over their parliaments, allowed it to constrain accountability mechanisms such as opposition day and backbench debates during crucial periods of the Brexit process. And although post-legislative scrutiny of key Brexit statutes would be desirable, as the Lords Constitution Committee has argued, so far the government has not shown any intention of facilitating this ahead of the normal schedule. The debate about how to hold the government to account for its performance during the pandemic is a live one. The NAO and parliamentary committees have made a start with focused inquiries, but there is a clamour for a judge-led public inquiry, which Boris Johnson has now promised will begin in 2022. The Institute for Government has argued, along with many others, that that will be too late to learn the lessons that might inform the government's response to a possible third wave. But the power to establish a statutory public inquiry under the Inquiries Act 2005, not of course the only option, but the one the government seems to have chosen, lies with the executive, so the timing is for it to determine. When the coronavirus inquiry does take place, its role will be to answer three questions: what happened, who was responsible, and what lessons can be learned. Whether its answers will come in time to hold today's ministers to account for their successes and their failures is uncertain, but in truth, the most important question is the last one. The inquiry will be a success if it identifies lessons that can be cast forwards to improve institutions, regulations, and behaviours and prevent any mistakes from being repeated in future. In addition to accountability mechanisms, a second means of protecting the Constitution from time pressure is to build in constitutional pause buttons, which should operate even under time-pressured circumstances. We already have an example of a procedure designed to do just this, namely the relatively new convention of parliamentary sign-off on decisions to commit UK troops overseas. This developed as a means for Parliament to put a check on the prerogative power of the executive, but it is also a means of slowing down a rush to military engagement, of asking the executive to press pause or even stop before exercising its prerogative powers, as David Cameron found to his cost. Might there be other prerogatives it could be appropriate to limit in this way, to require reflection and reinforce democratic legitimacy for constitutionally significant decisions? Following the events of 2019, we might argue for parliamentary endorsement of a decision to prorogue Parliament. This would still normally be a formality, given the executive would have the majority to pass it, but it might act as a protection in exceptional circumstances. Another desirable reform would be to allow Parliament the right to recall itself from a temporary adjournment, a power which is currently reserved to the government, to provide an injection of accountability in circumstances when the government would otherwise be acting with limited scrutiny. A third means of protecting the Constitution from time pressure is firmly to distinguish decisions taken under time pressure from the rules that operate in more normal times. Ronan Cormacain has written about the desirability of socially distancing emergency laws from ordinary laws, structuring them in ways which mitigate the risk that they contaminate ordinary law with their extraordinary provisions and practices. Some of the measures that Cormacain recommends for distancing emergency laws from ordinary laws apply equally to other aspects of the Constitution, for example, to parliamentary procedure. They include incorporating sunset clauses, containing emergency measures in a single legislative vehicle, clearly labelling provisions as temporary, and creating powers that by definition can only be used during the emergency. Measures to socially distance laws and practices adopted during the exceptional circumstances of the Article 50 process and Covid-19 have been inconsistent. The government chose not to include sunset provisions in the EU Future Relationship Bill, passed in a single day against the 31st December deadline, nor to apply the Trade and Cooperation Agreement provisionally to allow time for proper parliamentary scrutiny of the constitutional issues and policy decisions it contained. This was the approach suggested by the Lords Constitution Committee at the time, and the one adopted by the European Parliament. The Coronavirus Act, passed rapidly in March 2020, did include a sunset provision. It will expire 2 years after it was passed. And during the Act's passage, parliamentarians added a further safeguard against the prolonged use of its oppressive powers, a 6-month parliamentary review. but the sunset clause was diluted by provisions allowing ministers to alter the expiry date of any part of the bill by 6 months, a power that can be used repeatedly. The Coronavirus Act looked like a laudable effort to contain COVID-related emergency measures in a single legislative vehicle, as recommended by Cormacan. However, this and the protections built into it look less useful when you realise that of the 427 coronavirus-related regulations laid to date, only 22 have been laid using the powers in the Coronavirus Act. Most of the regulations passed to introduce and modify lockdown restrictions have been made under pre-existing public health legislation. And as the Hansard Society has documented, the government has made use of powers contained in 119 other acts, 5 orders, and 5 retained EU regulations to make coronavirus-related secondary legislation. So, while we already possess some of the tools we need to protect the Constitution from time constraint, crucially, in practice, their effectiveness is determined by whether and how they are deployed. A word in conclusion. I've argued that time constraint creates risks to the Constitution. We must recognise these and think about how to bolster the Constitution against them during the more normal times that we are all hoping lie not too far ahead. But I also recognise that time constraint can be valuable. It focuses minds, ensures decisions are made, and helps the public understand that action is being taken. Consider the contrast for a moment between the COVID-19 emergency and the social care crisis, which, despite millions of families having to cope in the most difficult circumstances, the pressure for timely action never quite overcomes the major political and financial obstacles facing any of the governments that have promised to solve it. Sometimes time pressure is necessary to galvanise the action the public wants to see. But when the Constitution is working against the clock, we must not allow the need for action to undermine the institutions, rules, and relationships on which our system of government relies. Thank you.